Hello, everyone, and welcome to the Phase 1 Site Assessment webinar as presented by the Waterfront Law Team and MSA. We're thrilled you can join us for today's presentation. Before we get started, we have a few housekeeping notes to share. Please make sure your cameras are on mute. During the webinar, feel free to drop questions in the chat function. At the conclusion of our event, we have allotted time to answer those questions. And lastly, we will be recording today's webinar. Once we have concluded the webinar, we will post our recording to the Waterfront property website. Both the presentation and the PowerPoint slide deck will be available at this time. And now I'd like to introduce you to our host, Jim Lang. Jim is a shareholder and Chief Operating Officer at the law firm of Pender & Coward. He focuses his practice on protecting Virginians who live, work, and play on the water. Jim established the Waterfront Property Law Practice Group at Pender & Coward. He and the other 3 attorneys in this group routinely handle all aspects of riparian property rights law, maritime and admiralty law, and environmental law. Clients consistently turn to the Waterfront team when they need help in court, at local wetlands boards, and the Virginia Marine Resources Commission. Also joining us today is Charles Hall, shareholder and Director of Environmental Sciences with MSA in Virginia Beach. Aside from leading the environmental team as a Virginia licensed professional geologist, Charles is accomplished in the area of hydrogeology, to include groundwater and surface water quality issues. He manages several environmental disciplines, from wetlands and CBPA issues to environmental site assessments, contamination investigation and remediation, drinking water compliance, and wastewater disposal. This work has given Charles in-depth knowledge of regulatory agency requirements for obtaining and managing a wide range of environmental permits. And with that, it is my pleasure to turn it over to Jim and Charles.
We are glad you're with us. Good morning. Quick slide on what we're going to cover today. 2 main issues. How does a Phase 1 environmental site assessment shield a prospective purchaser from liability? I'll cover that topic, and then Charles will give you some in-depth knowledge on the Phase 1 ESA, and then of course we'll leave some time for questions at the end. So background, back in the day before we had environmental laws, people could dispose of their garbage, their waste, their hazardous substances, their chemicals, pretty much however they wanted. And in some locations, people would just throw it down the side of a mountain, and it was perfectly legal to do that. And when you have unrestrained waste disposal practices like that, it can lead to a problem. One of the most prominent being Love Canal in the late 1970s. How did Love Canal come about? Well, what you're seeing is an aerial photo up in New York with the Niagara River on your left. And then far to the right off the picture is the upper branch of the Niagara River. And William Love wanted to build a model community in the open space between those 2 rivers. And he came up with the idea of connecting the 2 parts of the river with a canal as creating the water flow that he could use to generate the energy source to fuel the city. He got about a mile of his canal built, never connected to either side of the river, when he ran out of money and had to give up the project. So there sits a 1 mile, 15-foot wide, 10-foot deep trench in the earth for the next, 15 or so years. Quick aerial photo of Love Canal. The red line is the 1 mile trench. And you can see in the satellite photo, there's no development around the canal, and that's for a reason. And just tuck away in your mind, up the top right of that red line, just to the right of it, you'll see a little stub of a street running parallel to it. That's 99th Street, and that'll make sense to you in a minute. So there sits the canal, and on comes World War II, and an industrialist who's making a ton of money off of supplying chemicals to the Department of Defense during World War II has all of this waste that he's got to get rid of, and he ends up dumping all of these 55-gallon drums containing all kinds of hazardous waste into Love Canal, fills it up. There's 21,000 tons of hazardous chemicals now filling that trench. Again, all of this perfectly legal back in the era before we had environmental laws. After the war is over, Mr. Hooker and his company backfill the canal with 4 feet of clay. And a little more time passes, and along comes the city of Niagara Falls. The Board of Education says, we want to buy your property. And Mr. Hooker says, no, bad idea, terrible place to build a school. But the city says, well, you really can't stop us. We've got condemnation power. Mr. Hooker says, well, let me show you some borings so you can see what's under here. Again, terrible place for a school. And the city says, did you hear us the first time? We have condemnation power. We could make you sell it to us. So Hooker ends up selling the property to the city for $1 and gives them full written disclosure of the extensive contamination that lays 4 feet beneath the surface of the earth. And what the city do? This is where the 99th Street comes in that I mentioned a little earlier. They build a school on the site, the 99th Street School. And then over time, over the next 30, 35 years, 25, 30 years, neighborhoods fill in around there. Lots of homes, a couple more schools beyond the 99th Street School. And that's the situation until the late 1970s, particularly 1978, a year with record rainfall. And as a result of that rainfall, the contaminants from all of those drums is now migrating, and it's seeping into in the basements of people's homes. It's getting into the schools. There's toxic chemicals in puddles on the ground. The air smelled awful. Kids coming home from playing with burns, chemical burns on their hands and faces. When you've got, maybe over 1,000 families living next to this place, it's enough of a problem that it's going to get some attention. And I give you the date August 5 because it's interesting to see how quickly things moved after the New York Times on August 5 runs a big expose under a front page headline called "Time Bomb in Love Canal." And within 2 days, you've got the governor saying, oh, the state's going to purchase all the homes that are affected by this contamination. And you've got the president of the United States expanding the emergency financial aid program so that federal dollars under that program are for the very first time used for something other than a natural disaster like a hurricane or a big fire. The Senate gets in the act and adopts a sense of Congress resolution. And within 3 weeks, by the end of August, almost 100 families have been evacuated. And within a year and a half, in 1980, over 500 of those homes have been purchased by the federal and the state government. So a lot of action by the government, but then there's the question of, who's going to pay for all this, and how are we going to deal with it going forward? And the answer to that is a big piece of legislation in 1980 called the Comprehensive Environmental Responsibility, Compensation, and Liability Act. And I underlined the word liability for reasons that will be clear in a moment. But it's also simply referred to as CERCLA or the Superfund law. And where the Superfund name came about is one of the components of the law was the law placed a tax on the petrochemical industry in the US. And the funds that flowed out of that tax were segregated off into a discrete fund that could only be used to clean up hazardous waste disposal sites. Love Canal was not the only big contaminated piece of property in the US. There were thousands of sites where hazardous waste had been disposed through, the 200 years of our country's history at that point, when there were no environmental laws and you could just take stuff out back, dig a hole and bury it. And there were, any number of just dump sites where communities all brought their trash, all unregulated. And now there's a recognition that we've got to clean this up and we need money to do it. And so this super fund, if you will, was created by the tax put on the petrochemical industry. So that's going to create one source of fund, but who else is going to pay for it? Well, within section 9607 of the law is where the liability piece comes in. And the reason I underlined liability is because the liability created under this act was remarkable in one respect. And it's this: the liability was made retroactive. Joint and several liability is nothing new. It's been around in the law forever. What joint and several liability, the way it operates is, if you have a group of people that are jointly responsible for something bad happening, if the liability is joint and several, then the injured party can collect the entire amount from any one of the people who is in that category of being jointly and severally liable. The injured party doesn't have to worry about collecting the proportionate share from each person who's responsible. They can get it all from one and then leave that one person to use the legal system to try and get contribution from others. So joint and several liability has been around forever. It says all you have to do is find one person who's responsible with deep pockets. You can get all of it from them. That's been around forever. But retroactive liability was something new, because what it meant is, for a site like Love Canal, or a site like any of the other thousands of dump sites around the country where unregulated waste disposal had gone on for a century or more, the people who had contributed to that back in the day are going to be liable, because under the Superfund law, the liability is retroactive. And that made this law remarkable. Specific categories of liability under the Superfund law, there are 4 specific categories. Whoever owns Love Canal today, or at the time of the cleanup, would be one of the responsible parties who would be jointly and severally liable. Another category of people are the people who owned the property at the time when the waste disposal occurred. So this is how you get Mr. Hooker. He sold the property back in the 50s. Now fast forward, it's the 1980s. The federal and the state government have spent all this money to relocate or to purchase 500 homes, not to mention the cleanup costs. And so the federal government and the state government come knocking on Mr. Hooker's door, and he ends up paying out vast sums of money, as you can see under the third bullet on the slide. So besides the current owner of the property, besides the owner of the property at the time when the disposal occurred, the third category is anybody who generated the waste, and that would, in this case, be Hooker. They generated it as a byproduct of their World War II chemical company. And then the fourth category is anybody who arranges for the waste to be disposed at the location. So we're talking people who transport it there, being one example of an arranger. So CERCLA liability, in addition to being retroactive, in addition to being joint and several, it also created a vastly wide net of responsible parties who could get tagged. And all you have to do is find one of these people with deep enough pockets, and they've got to pay for the whole thing. As a result of this, massive liability system, you can imagine what happened. After CERCLA got adopted, any property that was contaminated, nobody wanted to buy it, because as the current owner of a contaminated piece of property, you're going to have liability, even though you didn't create the pollution. And so for the next 20 years, what we saw happening is contaminated properties just sitting vacant, and they came to be called brownfields. So they're sitting there, they're not productive. Nobody's cleaning them up unless the government could find somebody with enough money to make them clean it up, or they could be prioritized for a cleanup using Superfund money. But there were a vast number of properties that just were sitting idle and unproductive. And so in 2002, the law was amended to create a safe harbor for somebody to come buy the contaminated property and not have this massive amount of liability hanging over their head. Prior to the 2002 amendments, the only defense, if you were the current owner, was to say, well, the contamination happened through an act of God, or it was an act of war that put this contamination there. very narrow defenses. But in 2002, there were two new provisions put into the law. And the practical effect of these two provisions is it created a huge incentive to do a phase one environmental site assessment. And here's how. If I'm going to talk about the innocent landowner defense and then the bona fide prospective purchaser, but here's how it works. If you're considering buying a piece of commercial property, if you did a phase one environmental site assessment and it came back clean, you're told the property is clean, you could purchase the property. And if afterward you found out the property was contaminated and there's a huge expensive cleanup that has to happen, you could use the innocent landowner defense saying, but I, as part of my due diligence, properly investigated the property ahead of time. Here's my report from my environmental professional telling me the property is clean. That's enough to shield me from liability. You know, go after all those other people who are responsible properties under CERCLA, but I have a defense. Well, you do your phase one environmental site assessment. You don't always find that the property is clean. Sometimes you find that there's contamination. That's where the bona fide prospective purchaser defense comes in. And there's certain things you have to do, but to be eligible for that defense, we're going to look at those now. So up top, you can see the innocent landowner defense and the type of things you have to do to be covered by that. But let's drop down and talk about, you do your phase one environmental site assessment and they find some contamination. Well, you have to report the findings to the regulators. And if you buy the property, you have to do some common sense things like you can't allow continuing releases to happen, and you have to make sure that you're not going to increase, human exposure to the contamination. But you accomplish those sort of minimal requirements. And if the regulators end up driving a big cleanup at the property, you're not going to be on the hook to pay for it, even though you bought it knowing it was contaminated, because you got an phase one environmental site assessment and you fulfilled your obligations in the aftermath of that. One of the things, if you're buying a piece of commercial property, that is essential is that you have the contract clauses in the purchase and sale agreement that provide for a suitable study period. Why do you need a study period? You need to conduct your due diligence. You need time to get your environmental site assessment done. So you need at least 30 days, 45, 60, 90 days is far more mainstream. And you want your clause in the contract to require the seller to cooperate, like, give you certain documents about the property and cooperate if you want to go on the property and conduct inspections. And during your study period, you're not limited to only doing your environmental site assessment. You can also look into all of the other things you need to know about the property and whether it's going to be suitable for your intended use. But your environmental site assessment is one key aspect of your due diligence during your study period. And a properly written contract clause providing for a study period is going to make clear that if you, the purchaser, decide not to purchase the property prior to the expiration of the study period, you get all of your earnest money deposit returned to you. So those are the legal reasons why you need to do an environmental site assessment. Let me turn it over now to an expert on how to do an environmental site assessment, what's involved. So I'm going to turn it over to Charles. And Charles, thanks for joining us today.
Thanks, Jim. Good afternoon, everyone. You just heard a rather compelling case, the Love Canal incident, that certainly highlights the importance of having a thorough understanding of a piece of property that you might have an interest in. The environmental site assessment, in a general sense, is an investigation and then evaluation of a piece of property to determine if there's a potential for some sort of environmental condition that might present a risk to a current owner or a future owner, or even an adjacent property that might present a liability risk to you. But initially, as Jim pointed out, the original purpose for the environmental site assessment was to obtain protections against CERCLA liability in owning a piece of property or using that property. Since then, the phase one environmental site assessment has become to be used by landowners, investors, attorneys, lenders, financial lenders for the property, and even some municipalities use site assessments in considering applications for conditional use permit or rezoning. So initially, site assessments, they weren't always called that, but they started in the late 70s, partly in response to incidents like Love Canal. There was no standard when they first started. So the American Society for Testing and Materials came along and created a standard for people in industry to follow. That initial standard, ASTM E1527-93, was introduced in 1993, and it was a good thing to come about because it established credentials for the practitioner to meet. It also established some of the required elements that need to be in that report, and how you address concerns or recommendations. So it was an important instrument, and now it's pretty much an industry standard. Everyone requires you to follow that standard. The current standard is from 2013, and it's under review. The typical practice for ASTM is to review their standards every 8 years, and this one is under review now, and we may actually have an update by the end of the year. So what does that standard require in preparation of a phase one site assessment? We're required to look for recognized environmental conditions, or RECs, or RECs, as we call them. And it's the definition of a REC is long, but I'm going to paraphrase it. The REC is defined as the presence or likely presence of a hazardous substance or petroleum product on or around a property that could affect your property. That will be evidenced by either a documented release of a substance or a condition that's indicative of a potential release of a substance, or a condition that might pose a material threat to a release by one of those substances. So we look for these RECs on a subject property, and there's a wide variety of clues and details and things that we would look for on a property. In 2013, ASTM added 2 more categories. One is an HREC, that's a historical recognized environmental condition, and a CREC, which is a controlled recognized environmental condition. The HREC is a facility or a property where there was contamination and it has been remediated. They've done a cleanup, and it's to the satisfaction of the regulatory agency. And here, that would be the Department of Environmental Quality. A CREC, or a controlled REC, is a property where you have a contamination source, but you have not cleaned it up. It's become, you've taken it out of concern by some sort of action you've taken on the site. And that might be an institutional action, such as the locality changing the zoning or saying you cannot build something on that property, or an engineering control where you've paved over a property to reduce the pathway to human exposure, or maybe an activity use limitation, which would be a deed restriction, something placed on the property that says if you have a shallow contamination, you might put a deed restriction that says you can't install a well to produce water. So the CRECs don't actually clean up a property, but you've satisfied the agency that there's no longer a risk posed by that. And then more recently, another feature that we use when we prepare environmental site assessments is something that's not covered by ASTM, but it's called a business environmental concern. Again, these features aren't required by ASTM to be identified, but they are of interest by property owners or users of a property. And those might be things such as asbestos-containing materials, lead-based paint, indoor mold, wetlands on the property, or even if a property has an environmental permit, and we found that the permittee isn't doing their required compliance work. That shows kind of a pattern that might suggest that other areas of interest need to be looked at there. So, how is a phase 1 environmental site assessment prepared? There's basically 4 steps. The first is to review environmental records. There are dozens of environmental databases out there that are prepared by localities, county or cities, health departments, the DEQ in Virginia, or federal agencies. We review all of those records to determine if there's been any incidents or any permitted activities or something that might be of interest to us. Then a site visit is performed where we go to the property and look and see what we can find out about current activities or clues about previous activities on the property that could suggest an environmental concern. We also interview the current property owner and a prior property owner if available. And if a property transaction is not confidential, we'll actually like to talk to on-site people because sometimes they're a little bit more forthcoming with background information on a facility than an owner may. And finally, all of that's reviewed and reported in a way that's useful for the client. That report would include all of the findings. It also includes a section on our opinions. What do we think about all that? And then it'll present conclusions and recommendations where needed. So how long does it take? One of the 2 questions people always ask, how much does it cost and how long does it take to perform? Typically, site assessment can be performed in 2 to 3 weeks. There are constraints that can make it take longer. For instance, if the site's undeveloped versus developed, site access, do we need keys to get in? Do we have to come after hours, or do you need an escort? Also, the history of the property. If there's a long history, a lot to write about, it could take longer to prepare a report. Some things we don't control would be interviews that I mentioned earlier, or getting documents back from an agency through the Freedom of Information Act request. So these are some things that can take time to get the report done. And of course, all of that has to be written out and completed in the final report. So typically it's about 2 to 3 weeks though to finish a report. Then of course, the big question, how much does it cost? Every once in a while I come across a party that will tell me something like, hey, so-and-so is going to do it for $100 or $200 less. And, some people view this as kind of like a service commodity, a box to check in a process of a property transaction. But really, it's fairly cheap insurance. And I think the most important question is, are you qualified to do this type of work? But the typical cost for a phase 1, if there's a typical site, would be around $2,000. And larger or more complicated properties might take $3,000, $4,000, $5,000 to do. So just for fun, I've come up with some things that we look at. Again, there's a wide range of features to look at when you're evaluating a property, but I just came up with a group of pictures of some plates that you might see on the ground to review and give you an idea about what you might look for. So in the top left, you see that triangular cover. That is the classic symbol for a monitoring well, the triangle. So in this case, the cover itself is a triangle. So that's very obvious to us that's a monitoring well, which most of the time is used to look for contamination of some sort. And so you see that, it's going to raise a concern. The next picture over beside that is another monitoring well. But this one's a disc. It's a circle. There is no stamp of a triangle on there. There's nothing else that might indicate what it is, but there is a writing on there. I think it says something like MW and a number, which would be a monitoring well. So that gives us an idea that we got a monitoring well there. The next 2 pictures on the top are small discs, these bronze fixtures. They look very similar. The one on the left has an indentation in the middle, which is a plus or a cross. and the one on the right has a square indentation. So they take special tools to open. The cross-shaped fixture is actually a fill port to a heating oil tank, whereas the square-shaped indentation is a sanitary sewer cleanup. So they both have very different implications on the environmental integrity of your property. On the bottom row of pictures, you see the first one on the left is a fill port for a gasoline tank. It's an older style fill port. And so we know there's an underground storage tank below that. The next disc with that kind of alligator skin pattern is another clean out. It's a different type of clean out, and but for a sanitary sewer system. Then that yellow cover is a inspection port for a natural gas pipeline that has cathodic protection. So here's a way that the inspector can come and see if the sacrificial anode is still in good shape. So we know that there's a gas line under there. And then finally, the last picture on the right is an old style gasoline underground storage tank fill port. So again, you need to have all these experiences to understand what some of these different features are you might see. Well, another slide here shows some monitoring wells. So in the top left, you see a steel casing with a locked top, and this is in a beach environment where there's obviously a concern about the groundwater quality here. Whereas the next picture to the right of that with that blue casing, you might think that's a well. It's in front of a gas station. It's a steel casing with a locking top, but it's actually a city monitoring point for drinking water. So the city can actually get samples of water without having to knock on your door and test if the required amount of chlorine is still present. But below that, you see some PVC fittings, which you might recognize as a sanitary sewer cleanout. But this is actually an inexpensive temporary monitoring well that was installed. So again, it really helps to have a good understanding about what features are, but most important to ask questions when you see some of these things. The picture on the right shows a piece of PVC piping, if you can see that behind the fence, coming out of a building. And you might think, okay, that's a vent for a bathroom or maybe a dryer exhaust vent or something like that. But this is actually a former dry cleaner, and there's dry cleaning solvents in the ground beneath this structure. And that pipe there is a active ventilation system to exhaust harmful vapors that would otherwise collect inside the building. So there's a power fan, if you can see, like midway up that pipe along the wall. That's an electronic fan which draws the vapors from underneath the building. So again, it's really important to be able to recognize some of these features. The last two I want to present kind of interesting cases here. The top left is from a local military installation, and that concrete pad covers an underground storage tank that contains diesel fuel. If you can see in the end of that pad closest to you, there's a white circular disc with a black triangle on it. That black triangle, as we mentioned earlier, means it's a monitoring well. While in the background of that picture, there's a yellow disc. That's your fill port for this tank. But unfortunately, the fuel supplier came and filled the monitoring well instead of the fuel tank. And so we discovered quite a bit of oil in our monitoring well. And so this picture was taken while we're doing an investigation to see how far that contamination had spread. After that, we asked them to post a sign, which is actually shown there behind that concrete pad, that says, "Please do not fill. This is a monitoring well." Again, it helps to recognize some of these features. The last picture I'm going to share with you is an interesting case. This is a commercial office building north of Gloucester. And the fellow wanted to purchase this thing, had us prepare a phase 1 site assessment, which seems pretty straightforward. But we found out that this was actually a former gas station. It was a single-story building where the owner at the time had put a second story on there and dressed it up a lot. The window on the right-hand side of that building was the entry door, and then on the left-hand side of the building, that was the service bay for the automobiles. And in the parking lot in front of that building is where the underground storage tanks are. So that was kind of a surprise for them. Another interesting find was, since this is outside of an area that's served by municipal utilities, the drain field, sewage drain field, which is behind the white fence, happened to be impacted with radiator fluid and used oil, where when this was a service station, the mechanics would often pour these things down the drain, which therefore it ended up in the drain field. So it's kind of an interesting story, kind of a surprise for the buyer, but at least he had the opportunity to be aware of these environmental issues before he bought the property. So there's a good story there.
Well, and Charles, that was great. Thank you. And I'm just thinking about the buyer for that, innocuous looking office building, thinking, what's the big deal? But to have bought that property and then found out afterwards, because they didn't do an environmental site assessment, found out afterwards that you've got, all this contamination in the empty space right next door because of the things that the gas station had released into that drain field, and potentially be on the hook for a big cleanup. That would be a very unpleasant, a real case of buyer's remorse.
Yes.
If you don't look before you leap. So we've given you a slide here with a couple of additional resources, but I think we've probably reached the point where we'll check and see if there are any questions.
This now concludes the live presentation, as Jen mentioned, and we're going to open it up for a Q&A. We hope you enjoyed today's Phase 1 site assessment webinar, and we thank you for attending.
Okay, thanks, everybody.
Thank you.
And as always, if anyone has any questions we were unable to get to, please feel free to contact Jim at 757-502-7326 or via email at jlang@penderandcoward.com. Or you can reach Charles at 757-490-9264 or via email charles.hall@msaonline.com.